Delaware, Ohio. And you have a right to have what's called a Rule 4 hearing here to make sure you are the Daniel Charles Warren that they have a warrant for, and that I should order you to go there on this warrant. You can waive the Rule 4 hearing. If you do, then they're asking for a $2,500 cash or surety bond. If you can post that, I'll let you go turn yourself in Delaware. If you can't post it, I'm going to give them a reasonable time frame to come down here and fetch you and take you to Delaware. How do you want to proceed? Do you want to have a hearing here, or do you want to waive the right to hearing and agree to go to Delaware, Ohio?
We'll have a hearing here, nothing come get me right.
Well, if we're going to have a hearing here, then you're going to sit in our jail until we have a hearing. Do you understand?
No, I mean, just give them a few days of everything, get me whatever he's talking about.
Well, it's going to be more than a few days.
Yeah.
Can you post a bond?
Yeah.
So I'm going to give you, I'm going to say it has to be posted now, which you're telling me you can't post it. So I'm going to give them a week to come pick you up. That's the usual.
Yeah.
So that will be the 14th. So they're to come get you before 8 a.m. on that day. If you're still in the jail here next Friday, then I'm going to see you again, either like this, probably on the teleconference.
Yeah.
And I'll decide what will happen then. So I'm putting him on the docket. March 14th at 10 a.m.
Good.
So this is the waiver I'm going to ask you to sign. This just says I don't want a hearing on whether I'm the person that they're seeking up here. You're agreeing you're the person they're seeking. Because if you want to have a hearing, I'll set it like in a week and you're going to sit here. It just puts it off longer. You wind up sitting in jail longer. So if that's what you want to do, you need to sign that document. So the jail can notify Delaware County he's available to be picked up now for a week. If they need more time, they'll need to contact and move for that. Okay? That's all.
Thank you.
You're welcome.
State of Ohio recalls Brittany McKenzie.
Your Honor.
CRA 25118.
We're going to take testimony on Mr. McKenzie. We're not going to take testimony on Mr. Tackett. So if you want to call him first, that may be a little quicker.
How about Mr. Ward?
Mr. Ward is set back for Monday.
Yeah, he's on. We don't have to recall him.
State of Ohio versus Jason Scott Tackett. Case number TRC 25353, A, B, and C, TRD 1742, A and B, and others.
RRS can take Mr. Tackett. I will say the same thing Mr. Tackett I was saying earlier. I don't know if he's going to be on the monitor. It's noon on Friday. I don't get any feet in the monitor until Monday.
So I'm going to put him on the docket for Monday, 10th. But I'll let him go to RRS if they get an ankle monitor done this afternoon. They can pick him up, but it's probably not going to happen.
Thank you.
So we'll put him on the docket for March the 10th. And he's going to be still in the jail, which is probable.
Thank you.
Okay. You're welcome.
State of Ohio versus Darius S. Aldridge. Case number CRA 2512, here.
Aldridge is coming in.
Yeah. Okay.
Natasha.
Natasha?
If I could have a moment to speak with them.
Sure, we need a minute anyway with the clerks dealing with some computer issues.
off a little bit. Okay. Okay. All right.
Your Honor, I've spoken with our victim in this matter, and I believe we've reached an agreement as to how it's to be resolved. This is,
So are we ready to, no, we're not ready. She's catching up on some other cases we just flew through.
Date, but I'm gonna write the other date off here. Yes. Let's take a look at that. So you're thinking past that, or you think maybe okay. So maybe like April the 11th. Okay. All right. So, this is one of the new comments with Will Smith. Suspended time, which you have to pay 3 days, we'll see about for April. And then after you're done here, you go to John Wayne with the probation. Okay, and then you'll do on probation for probably 2 years time. So, yeah. Yeah. It's just a bad day, you know? I'm confident the judge will go along with the recommendation.
So he gets an OR if they're not picking him up. He's got to have him on. I need to put that in there. It's about.
Put the monitor, right, with his OR. I'll go back into OR.
I said 3 times right here.
Only if he gets the monitor on, which is probably not going to happen.
What was the OR on?
Let's make it 15, it was 15,000, make it 15,000 or more.
If the court's ready to.
Are we ready?
Yeah.
Okay, we're ready.
So we reviewed this, it was set for trial today, and we determined that, and there was an agreement that aggravated menacing was probably a better charge given the circumstances. This occurred at the Giovanni store in Chesapeake where Ms. is it Lawhorn or Lahan was employed, and Mr. Aldridge went in there and raised a ruckus and swung at her and threw a tip jar at her. Didn't actually physically harm her, but it was completely uncalled for. She's working behind the counter there as an employee. And so to resolve this, we agreed that we would move to amend the charge to aggravated menacing, and if he pled guilty, our recommendation was going to be 60 days in jail with 57 suspended and an order to stay away from that store, and also Ms. Lahan. We didn't discuss
Is that one
anything.
right down here? Right down the road here?
We didn't discuss anything about fines, but we would want a period of 2 years probation.
Your Honor, that is our agreement. We'll plead guilty to the charge. Ask that he be allowed to serve the 3 days. We were thinking about April the 11th. He has some health issues he needs to address. So if we can make that as maybe a jail report date, maybe even report here to go to jail, or just report to the jail to do his 3 days. And then we just ask that the rest of the time be suspended.
I'm reading that.
Oh, okay.
So there's no prior relationship at all? I'm wondering if there needs to be some sort of evaluation. It seems like pretty bizarre behavior to me.
It was a bad day, Your Honor. It's out of character for him. He can explain it better, but I also like to note for the court that in there, he admitted to it to the officer, was very, very upfront with the officer, spoke to him. It's at the last bit of the narrative there. So he never denied that the incident didn't happen.
Okay. Mr. Aldridge, you have a right to make a statement if you wish to the court before sentencing. Do you have anything you wish to say?
Yes, Your Honor.
Yeah, go ahead.
I wish they would have had video. Basically, I'll stick to the statement. I wish they would have had video. I admitted to it, but I never tried to hit anyone. I threw it way over the tip jar. I threw it over her head. She was acting like a woman child, and I went in to get something to eat and have a discrepancy taken care of about a $7 overcharge, and she just started screaming at me and acting like a woman child. And she kept telling me to bring the receipt back, after she told me there was nothing she could do, and she just started yelling at me, calling me a POS, and she kept demanding to bring that receipt back. So I brought it back and I put it in her tip jar and I threw it and I said, you can keep the tip. I never tried to hit anyone.
Well, you just told me that you're not guilty, so I'm not going to accept your plea.
Okay.
We'll go ahead and have a trial.
Your Honor, I think he admitted to the aggravated menacing. That's an admission to that, not an admission to.
We're having a trial. Court chair, we'll start now. Okay, state ready to proceed.
Yes, Your Honor, and we would, I think they stipulated that aggravated menacing, and we'd ask for that amendment.
Your Honor, if the state says we stipulate to aggravated menacing, we pled to an aggravated menacing, I just like to note that my client didn't. His statement had to do with an assault, not the aggravated menacing. His statement is right in line with
He needs to understand also that I'm not bound by the recommendation.
Yes, that's true, Your Honor.
Does he still want to go forward?
You still want to plead with aggravated menacing? Yeah, I do. Okay. Yes, Your Honor, we'll proceed with that, the plea to the aggravated menacing.
Okay, what's the statute number?
It is, I've got it here.
That's
20.
still only in one, isn't it?
It is, Your
Yes.
Honor.
Oh, no,
Yes.
I got the wrong. Let's see here.
I can pull it up.
$2903.21.
Okay, I'll allow the amendment to 2903.21 aggravated menacing. There's a guilty plea to that. So I've heard from Mr. Aldridge. So Ms. Lahan, anything you wish to say?
The tip jar physically hit me, so like he didn't throw it over me or anything like that, so.
Anything else you want to say
That's
based
it.
on
Thank
the
you.
statements he made?
No.
Okay, I'm going to impose a $400 fine for court costs to be paid. 30 days in jail, 27 suspended. Order they stay away from Ms. Lahan and the Chesapeake Giovanni's. I'm going to order they do 90 hours of community service. And they'll have a review hearing May 16th. And I'm going to order him into custody immediately. What I'm going to do is 3 days starting today.
Your Honor, I understand that he's on a litany of medications.
That's fine, the sheriff can deal with it.
Yes, Your Honor.
This is your contact order, so you need to sign it. Take the contact with you, do it.
I did that one.
Yeah, the other girl was supposed to be there.
Feel free to go.
Swear.
State of Ohio versus Brittany McKenzie, case number CRA 25118.
So that's to have Ms. McKenzie join the account today, we're going to take testimony.
We're not ready yet.
Oh, I'm sorry.
She can join you.
Yes.
She is.
Need Brittany McKenzie outside.
Yes, Your Honor.
Okay. You can come down and sit with your lawyer, man. Okay, so this is set for a preliminary hearing.
Your Honor, I'm going to ask that one of her hands, whichever hand she writes with, be freed so that she can take notes during the.
That's fine.
So just.
Stay ready to speak.
Yes, Your Honor.
Much here, but I'm going to ask if you.
We call Deputy Chin.
Deputy, if you'll come up, I'll swear you in. You swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God. You may be seated.
Deputy, state your name and where you are employed.
Deputy Matthew Chin, employed at the Lawrence County Sheriff's Office.
Were you employed with the Lawrence County Sheriff's Office on February the 19th, 2025?
Yes.
And on that day, did you respond to a call to 22 Private Drive 215, Apartment B in South Point, Ohio?
Yes, I did.
And what was the nature of the dispatch? Why were you called there?
I was dispatched there due to a vandalism.
Who lives or who was living at that address?
That would be Brittany McKenzie.
And do you recognize her in the courtroom today? And if so, can you point to her, please?
Yes, I do.
Record say pointing to the defendant.
When you responded to that dispatch and arrived at that location, what did you learn?
When I arrived there, I was met by the property manager or the overseer of the property, Mike Finley. He had stated that prior to February the 18th, his staff arrived there to do a inspection of the property, and that when they arrived at the door, Ms. McKenzie came to the front door and stated that, or asked if they could come back later. The staff then left, and then on the 19th, when they arrived back at the residence, they knocked on the door, was not able to get an answer. Whenever they opened the door, they noticed that the flooring had been removed from the property. When they stepped into the property, they then noticed that the light switches had also been removed, and along with the doors inside of the property and the heaters.
When you were there, was Brittany McKenzie there?
She was not. I was notified by the property manager that she was the tenant of the property.
Did you make contact then at a later time with Brittany McKenzie?
I did. I made contact with her on February the 24th.
Did you speak to her about the damage of the property?
Yes, I met with Ms. McKenzie at the Lawrence County Sheriff's Office. I was advised that she was there on unrelated charges. I then interviewed her, advised her of her rights, and spoke to her about the property. She stated that she was the only one that resided there, that she lived there. I asked her about the flooring. She stated that she removed the flooring due to mold being in the floor. However, whenever I showed her photos of it, there was only one place that appeared that there was some sort of water damage. I asked her about the electrical sockets along with the light switches, She stated that didn't know how they worked and was curious, so she took a pair of wire cutters and cut the wiring out. She then stated that everything was located in bags inside of the garage. So I showed her photographs of that as well. She made the statement throughout the interview that she had cut it out because the radiation was coming through the wire.
And to your knowledge, did the landlord or the property manager, or whoever, give her permission to do any of that?
No. When I spoke to the landlord or property owner, or manager, I'm sorry, they stated that in the 27 years that they have been renting properties, they have not seen any intentional vandalism to that nature. I believe they stated it was approximately around $11,000 in damage.
So in addition to the flooring, there was also electrical wiring that she pulled out and light sockets and things of that nature?
Yes, all electrical sockets and electrical switches throughout the apartment were completely removed along with wire.
That's all I have, Your Honor.
Mr. Sire.
You stated that this property was owned or managed by Mike Finley.
Yeah, he stated he was the property manager, but it was Point Villa Phase 3 was the actual name of the properties.
Is this the Mike Finley who sits on the Lawrence County Commission?
That is correct.
Okay. And he also is the father of Common Pleas Judge Finley?
Yes.
Okay. You stated that you interviewed the defendant and she waived Miranda rights. Did you obtain a written Miranda waiver?
I did. I obtained a written Miranda waiver where she signed off on, along with it was audio and video recorded.
And you say it was audio video recorded through what means?
Through a body camera.
Have you maintained that Miranda waiver?
Yes, it should be with the report or in addition to the report at the office.
And did you maintain the recording, the audio video recording of the interview?
Yes.
You stated that the defendant told you there was radiation coming through the wires.
That is correct.
Is that something you observed when you were in the apartment?
No, not that I'm aware of. I've never been able to see radiation.
So you don't believe that she was completely in touch with reality when she made that statement to you?
Not when she made that statement, I do not.
Okay. You mentioned that as far as you're aware, all of the allegedly removed property was in the garage attached to the. Is the garage attached to the apartment?
Yes, the garage was attached to the apartment.
Was it like a situation where you could walk in and out of the garage through the apartment, or you have to go outside?
You walk in and out through the apartment.
Okay, so, nothing was taken from the garage as far as you're aware.
Not that
It was
I'm aware.
placed in the. But as far as you're aware.
Yes, not that I'm aware of. There was flooring along with doors inside the garage loaded up into a vehicle that was registered to your client.
Okay, I was going to mention there's a vehicle in the garage.
Yes.
That vehicle was registered to my client.
Yes.
Did you cause that vehicle to be towed away from the garage or in any way?
No.
As far as you're aware, is it still in the garage there?
No, I was advised later on that family members had came and removed everything from the apartment.
Family members of whom?
Of Brittany's.
So it's your understanding that any belongings that were in the apartment and the garage that belonged to Miss McKenzie were taken by her family members?
Yes.
Okay. Just a moment. All right, I don't believe I have any further questions at this time, Your Honor.
Mr. Hill,
Nothing further, Your Honor.
you may step down, thank you.
We rest.
We're not going to present any witnesses, Your Honor.
Okay. There's probable cause to find the case over to the grand jury. What are we talking about? Treatment or what happened with that?
That was our intention, Your Honor. She is being held right now on a probation violation from Ironton Municipal Court. Mr. Heald contacted them and they are unwilling to release their holder. She's on that holder until the 13th. So I don't know that anything we do, I mean, nothing we do now can disturb that through the night, through the 13th. I would assume this case will go before the grand jury about a week or so later and will be in front of the common police court soon after. I'm actually not certain what the bond is, where the bond is set now. I think it's set at $5,000 cash or surety.
Correct.
A lower bond or even no lower bond with a requirement of treatment might not be out of line. She can't make that right now, but once she gets through Ironton Municipal Court sentence, if she could then sign a no lower bond and go into treatment, I don't think we have any trouble getting her into court in
So
the
she
common
has an
police.
outright jail sentence from Ironton Municipal.
Yes and no.
She has a hearing next Thursday. And I think a determination as to treatment and whatnot would be discussed at that point. I want her to go to treatment. In fact, really, upon thinking about this, and this is entirely, of course, up to Mr. Steyer and Ms. McKenzie, but if we just continue this for a week till we know what Ironton Municipal wants to do, and then we can, then you could get her in treatment before she goes to the grand jury.
I am here on the 14th. My understanding is that the probation violation is still pending, but that on or about the 13th, they run out of time anyway. So basically, they're just going to let it run out and then say, oh, time for a hearing, oh, we're done. If she's willing to come back here in a week, that's potentially keeping you one more day in, but we can maybe get you out. I think that I would advise her to agree to that, and we would waive time constraints to accommodate it if she says yes. That's not the question is, do you want to, instead of having the case end here today, we'll come back next week, and the same thing's going to happen. We might be able to get you out and go to treatment at that point. Yeah, you should.
Okay.
All right, we're agreeable to that, Your Honor. We would ask you to withhold your ruling for a 1 week.
Okay, I'll just take it under advisement and set it for a further hearing on the 14th. And we'll see what happens in our municipal, and perhaps then she can go to treatment next Friday. So the case will be rescheduled for decision on the bond over March 14th. Okay, court's adjourned.
Thank you.
Would she make
I'm sorry.
She was on Docket today.
They're saying it was on the docket. You call it.
Yeah, and I don't know why. I think maybe lawyer
Her lawyer wasn't here.
Adrian Price is here. She was on the docket. I don't know what happened.
I can't say who
I think.
Yeah, he must have continued it, and not told you, because he had to leave early today, and he must have not have told you or something. 'cause-
Just check in the clerk's office and they'll let you know when the date was.
I saw this.
He had a medical issue.
Yeah, and I didn't want to